Get ready for the dictation. Dictation will start in 5 seconds. Start. The guilt theory of divorce has been found deficient as it recognizes divorce only on certain specified grounds. The consent theory has been found wanting as it either makes divorce too easy or too difficult. The problem that the modern law faces is that if a marriage has in fact broken down irretrievably, maybe on account of fault of either party or both parties, or on account of fault of neither, then is there any sense in continuing such a union? Would it not be in the interest of both the individual and the society that the marriage is dissolved? From such a marriage, substance has disappeared, only form has remained. There is no use in retaining the empty shell. In other words, the law recognizes a situation and, in effect, says to the unhappy couple, if you can satisfy the court that your marriage has broken down and that you desire to terminate a situation that has become intolerable, then your marriage shall be dissolved. Whatever may be the cause, the breakdown theory of divorce represents the modern view of divorce. Recently, the Law Commission on Reform of the Grounds of Divorce said in its report that objectives of any good divorce law are two: 1. To buttress rather than undermine the stability of marriage, and 2. When regrettably a marriage has irretrievably broken down, to enable the empty shell to be destroyed with the maximum fairness and the minimum bitterness, distress, and humiliation. If a marriage has broken down beyond all possibilities of repairs, then it should be brought to an end without looking into the causes of breakdown and without fixing any responsibility on either party. In our contemporary society, the irretrievable breakdown of marriage theory is recognized by the laws of many countries. In or about 1950s, a trend towards this theory became discernible in those countries also which were deeply entrenched in the fault theory. Two methods were used. First, by enlarging the number of grounds. Such grounds as incompatibility to temperament were added. The Swedish marriage law of 1920 provides a very good illustration of this trend. It was laid down that both the spouses could represent a joint petition for separation decree on the ground of profound and lasting disruption. Such an application could be presented by one of the spouses to the marriage also. In the case of joint application, the court was required to pass a decree without looking into the matter. When only one spouse sought divorce, the application could be granted if the court, after an inquiry, came to the finding of profound and lasting disruption of marriage. The second method that was used was to give widest possible interpretation to the traditional fault grounds. Stop.